Everybody ready?
Yeah.
First, I would like to welcome everyone here today. My name is Alan Wilson. I'm the Attorney General of South Carolina, and I'm joined up here by several colleagues from various states around the country who have joined in a letter asking the United States Senate to reject the articles of impeachment because they are both legally insufficient and factually flawed. First, though, I would like to thank Congressman Meadows and Congressman Zeldin for being here today to support this opportunity to take our case to the American people. Today, we are submitting a legal opinion, a friend of the Senate brief, if you will, to the Secretary of the United States Senate to aid the senators in their deliberations. And in that letter, we are outlining the problems, both factual and legal, with the articles of impeachment that were passed last month by the United States House of Representatives. We are asking the United States Senate on constitutional and legal grounds, as well as lacking in factual sufficiency, to reject these articles. First, I want to state that impeachment is a legitimate constitutional tool for removing a president from office. However, it is a powerful tool and it must be used responsibly. Here, in this particular case, in this instance, it is not being used responsibly. When I was a young prosecutor, a more seasoned prosecutor gave me one of my first lessons in the courtroom. He says, Alan, as prosecutors, you don't prosecute the person, you prosecute the conduct. You don't prosecute the person, you prosecute the conduct. And what he was trying to tell me, and what I'm trying to tell all of you, is that if you take out the personalities, this is a very different case. People or prosecutors, people standing in judgment, should not allow their personal views or passions about an individual to affect their judgment in deciding when and how to indict someone for committing an impeachable offense or a crime. That's what's happening here. The impeachment articles 1 and 2, obstruction of Congress and abuse of power, are legally flawed, factually insufficient. They are inherently destructive of separation of powers, and they're contrary to the vision of the framers of the U.S. Constitution. This is all outlined in this legal opinion. But most important, there is an incredibly dangerous precedent being set here today. I don't want this precedent to exist. I don't want the House of Representatives to turn the presidency into a ward of Congress. I don't want the Democratic House of Representatives to have this kind of power in the future, and I especially don't want Republicans to have this kind of power. This is not about partisan politics. This is about creating a constitutional precedent that could harm our country for generations to come. The president, under Article 1, was basically impeached for the nebulous crime of abuse of power because he exercised his constitutionally permissible power of talking to a foreign head of state about concerns he had regarding the receipt of military aid. Now, take out the names in this. There are no names. This is what presidents do. However, the precedent that's being created under Article 1 is basically that if the House believes that the president will receive a political benefit, then that fact alone is proof of corrupt motives. Here they are prosecuting a person, not the conduct. This is also true if you look at the underlying issues that were raised in the call with President Trump and President Zelensky. Let's take out the names. Imagine President Trump threatens to withhold funding to Ukraine unless a Ukrainian prosecutor is not fired before investigating a company that President Trump's son would be on. We'd be having a very different conversation right now. But when that fact was raised this past year, we heard crickets. Here, it's the same thing. They are imputing a corrupt motive on facts that are perfectly permissible under our Constitution, and it is something that if this happens in the future, it is going to hurt presidents of both parties. Go back to 2012. President Obama overheard on a hot mic talking to President Medvedev of Russia about asking for flexibility until after the election so they could pick up negotiations on missile defense and other matters. Asking for a benefit, a political benefit, till after the election. It's the same concept here. That kind of stuff, we should not impute political motives, or corrupt motives rather, because when the conduct is purely purely permissible under our Constitution. Under the obstruction of Congress charge, this one is very troubling. When you read Article 2, obstruction of Congress, what you will not see anywhere mentioned in that article is executive privilege. Here's the problem I have with that. The president is allowed to invoke executive privilege when dealing with matters of national or international policy and military aid. If the House of Representatives did not think that this was an appropriate application of executive privilege, they could have taken the president to court, challenged the lawfulness of that invocation, and then heard from a court. But if we all remember, they did not want to wait. Remember what they said? This is too urgent. This is too important for our country. And so they rushed to basically claim that he's obstructing Congress for utilizing a constitutional power of executive privilege, and now they're impeaching him for it. The failure of the House to mention the president's invocation of executive privilege underscores the political nature of this impeachment process. This impeachment process is creating a very, very dangerous precedent that will make the president and all future presidents a puppet of Congress. I don't want any future House of Representatives, Republican or Democrat, to have that kind of power. That is why today I am excited and honored to be standing with some men and women up here, my colleagues from respective states around the country who have signed on to this letter asking Congress to reject these articles of impeachment and stop this dangerous precedent. At this time, I will be followed by my good friend and colleague, the Louisiana Attorney General, Jeff Landry.
Thank you, Alan. Again, my name is Jeff Landry. I'm the Attorney General for the state of Louisiana. I want to thank General Wilson and General Reyes of Utah, for working with us on getting this letter to the Senate. I want to thank my colleagues as well. You know, each and every day, Attorney Generals from around the country work to uphold the rule of law. Today is a disappointing day for America. For over a decade now, you have been hearing people like myself telling you all that there is a complete erosion in the rule of law. Today, it is on full display in the United States Senate. These impeachment articles would not hold up in any court of law. And impeachment was never designed to be a partisan response towards one party losing a presidential election. The weaponizing of this process it's a weaponizing of this process that should only be used in very rare circumstances. If the House can impeach a president for basically invoking executive privilege, then presidents from now on become mere congressional pets. And that is troubling. Our framers hesitated to give Congress impeachment power and only did so under very limited circumstances. Unfortunately, today, we see the rule of law being eroded, and we would hope that the Senate would be wise and reject these articles. I would now like to invite General Leslie Rutledge from the state of Arkansas to say a few words. General.
Good afternoon. Again, my name is Leslie Rutledge. I am the Attorney General of Arkansas. I am honored to stand with my colleagues, and I appreciate their leadership as Attorneys General from 21 states came together to write this letter to the United States Senate. We are the chief legal officers of each of our states, and recognizing the importance of the rule of law, recognizing what this impeachment trial has already done to the United States of America. What the House of Representatives has done is tear down and rip apart the threads of our democracy. We cannot allow one party to be so frustrated with the outcome of an election that they will undo our Constitution. Before this impeachment ever started, it was outcome determinative in the House of Representatives. And we are asking the United States Senate to reject these articles, to ensure that our democracy is strong, to ensure that all Americans are protected by the rule of law. As a prosecutor, I would have been ashamed to bring such a case with no evidence, no facts, before a jury. I would have expected to lose outright and to perhaps even be laughed at. But unfortunately, we have leadership in the House of Representatives that are so frustrated, not at what this president has done as president, but what they thought he had done. It is merely what they believe is the corrupt. There are no facts being presented to justify this. And again, we are standing here today as Attorneys General, the chief legal officers of our states, asking the U.S. Senate to reject these articles of impeachment. Now I'd like to invite up my colleague from the great state of Indiana, Mr. Curtis Hill.
Good afternoon. My name is Curtis Hill. I'm from the state of Indiana, Attorney General. And we are here to defend the Constitution. We are here to defend fairness. Now, in a court of law, we call fairness due process. And I've heard people say, well, this isn't a court of law, so therefore due process doesn't work. When did we rewrite the standards of due process and fairness? This particular vehicle, this impeachment vehicle, began when the Democrats took Congress. And they thought it was going to play out through the Mueller investigation, which did not play out. But the vehicle was left running with the engine on until another vehicle could come along. And that's not the way we play the game. I was a prosecutor for a number of years, and impeachment is tantamount to indictment. It's a charge. And when you make a charge, you need to have the information behind it clear and not vague, clear and articulable. We have two articles of impeachment that are vague, that do not set forth crimes, and it's appalling. As my colleagues have indicated, this would not stand in a court of law. It's completely anti-fair, and we demand that the Senate repudiate in the strongest terms this process and return it to fairness. Thank you very much, and at this time I'd like to invite my colleague from the great state of Alabama, Mr. Steve Marshall. General?
Thank you, General Hill. Good afternoon. I'm Steve Marshall, the Attorney General from Alabama. I appreciate the leadership shown by General Wilson and General Landry in allowing us to be able to submit this Friends of Letter brief. It is thorough. It is a full examination of both the facts and the law that the Senate has to apply. But despite that significant analysis, fundamentally what that letter about is the idea of fairness, or maybe better said, the lack of fairness. As a prosecutor for 20 years, what I've seen is an unfair process brings about an unjust result. And that is what the Senate now has an opportunity to stop. I also find it remarkable as somebody who has stood before juries and judges, who's brought charging instruments against defendants, to now hear the House say that they are not prepared and that they are not ready. What that simply shows is not that they are not prepared, is that they have no case. Our letter demonstrates the various reasons why the Senate should reject this effort, and we need to return the President back to the work of this country and Congress to be able to serve the people in which they were elected.
Courthouse News. Quick question, then I have a follow-up. You've all prosecuted a lot of cases. Have you ever prosecuted a case without witness testimony or discovery of evidence?
First of all, the first thing I would tell you is that before you'd even bring a case, you have to meet a litmus of fundamental evidentiary standards. And the problem we have here is exactly that. If the House, what we have today is a fishing expedition. And if the House continued to want to fish, they should have left it in the House and not sent the articles here. And that's the problem. Once you bring the indictment over, it means this is the best evidence I have. You don't continue on a fishing expedition.
So you're saying that you stop discovery of evidence once the indictment is charged?
So let me just speak. I mean, your premise is to suggest there was no witnesses. I actually was in depositions over 100 hours, 17 different witnesses. And so when we look at the witnesses and the evidence, it's the House's job to actually do the investigation. And now what we're trying to do is move that investigation over to the Senate. It's just not the appropriate place. It's not what our founding fathers set up. And candidly, it shows, as the general from Alabama said, it shows that they have no case and they're not prepared. And so I think it's important that we recognize the difference.
Thank you. Just a quick follow-up.
Majority Leader Schumer, or Minority Leader Schumer, told us this morning that a lot of the president's legal team was just playing to Fox News. What do you think? What do you hope to accomplish with this? Is this just for the cameras? Is this just for us?
Well, you're not with Fox. You're with Fox.
No, look again, and you know, General Hill, General Marshall, General Rutledge can tell you. I think again to his question, you'll have to recognize something. If we brought this case into a criminal court, the defense would automatically ask the judge, motion the judge to strike the case based upon a lack of evidence. And that's what we're here to tell you. There's a complete lack of evidence, whether they went through witnesses or not, whether they went through the documentation or not. This case should not be before the Senate today. And that's the problem. We're here today to say that there's a foundation in this country, okay? That a court of law is a place where you receive justice and fairness. And those people out there who are elected to serve in this Congress should respect that as well.
Fight to influence senators?
Well, we hope to educate and inform senators through the legal opinion. We also hope to, through all of you here today, to educate and inform the public, because they have a right to know what's going on in this building behind me. And back to the question the gentleman asked earlier, I've never taken a case to trial where I had not completely vetted all the witnesses. And listen, every trial has preliminary hearings where one side says, I want X document or talk to X person, and the other side says, well, that's excluded under the rules of discovery, and they have preliminary hearings, which is what a court would have done under the executive privilege invocation. So what the House basically did is they indicted first, now they want to ask questions, and that's the exact opposite of what you're supposed to do.
Question.
I didn't hear your name. Yes, actually, I met with one of my senators this morning. I met with Senator Graham and presented him with a copy of the letter prior to this. I also told him that we'll be coming up here presenting this, and he welcomed that letter to inform the Senate.
Has the Secretary of the Senate given you any indication about how your letter could be entered into evidence, provided to all 100 senators? What's the mechanism?
Well, we wanted to follow a process, so we sent it to the Secretary of the Senate because I believe that's where the articles of impeachment were presented. However, I've given a copy to my senator. I plan to give another copy to my other senator. I think the senators can receive whatever information they want, but we wanted to use the channels available to us to the Secretary of the Senate.
With regards to the recent GAO finding that the Office of Management and Budget found that there was an illegal withholding of funds to Ukraine, does that undermine your argument that it's without factual basis, the abuse of power charge?
Well, not at all. First off, there is a remedy in that law, which I believe is a lawsuit that can be brought against the president when or if any president violates that particular statute. So there's already a remedy in law. You're talking about removing a duly elected president in the United States for an alleged technical violation of a law when there's already a remedy in that law for suing the president. Why would they pass a law putting a remedy in there? Would impeachment be the logical jump when they put a remedy in the law to address that kind of thing? And also, that was never alleged in the articles of impeachment. There's not one violation of law or one alleged crime. And I know that a criminal indictment is not necessary, although I think this is the first impeachment where there has been no criminal allegation. But there's no criminal allegation in the articles of impeachment. Abuse of power, define that. Define obstruction of Congress. It's arbitrary. It's gray. I mean, there's no definitive elements for crimes for someone to protect against. So in that particular case, they didn't allege it in the articles, and even if they had, I would make the argument that there's already a remedy in there. If you believe a president has violated that statute, the remedy says you sue the president, not impeach him.
Just to be clear about the findings of that report, it doesn't undermine your arguments at all?
Not at all.
There's no factual or legal basis for these charges?
For impeachment? Absolutely not. There's
abuse of power and obstruction of Congress?
Absolutely. Absolutely.
And I think for the record, it's important to recognize that this isn't the first time the GAO has recognized that a president has violated that provision. So, so should we be impeaching every president before who has done this?
7 times under President Obama.
Quick question. You're all obviously state attorneys general. How does this advance the interest, filing this friend of the Senate brief, as you call it, of all the people of your state rather than a political interest as Republican AGs?
Well, initially, the citizens of South Carolina, and I think my colleagues up here would say the citizens of their state voted in the last presidential election. And well, we view, first off, my job is to protect the integrity of the 2016 election as well as protect the integrity of the 2020 election. But more importantly than those two elections, it's all future elections, and it's the very concept of separation of powers for here and evermore for every future Congress that has a relationship with a future president. Right now, if they're successful, basically they have made the president a subservient puppet, a pet, as General Landry referred to it, made the president a pet of Congress. If they can choose when they're going to accept executive privilege and when they're not, and if they can just say, hey, we're going to charge you with a thought crime with no evidence to support that thought crime, then we're going to impeach you for it.
Have the premise that
Right now, they can't talk. Did you guys talk to them? Because Democrats are in there. Like, guys might lead the news tonight.
I only spoke to
Yeah.
I only spoke to my senator when I'd already determined that I wanted to work with my colleagues, and I talked to a number of my colleagues about doing a legal opinion. Oftentimes, the attorneys general, we have a bag of tools in our toolkit. When there's a lawsuit, we can join in a complaint if we have standing to do so. If there's a legal issue that we're not a party to, but we're concerned that it might have an adverse effect on us as a stakeholder, we can file a friend of the court brief, an amicus brief, if you will. And we also, when there's a rule or a law being tossed about in Congress, we will oftentimes sign on to a letter arguing on policy grounds why members of Congress should or should not vote for that law because of the adverse effect it may have on our states. This is a very unique situation behind us. This isn't a law being debated. This isn't a rule being promulgated by some federal agency. This isn't a complaint or a lawsuit going on. This is an impeachment of a president. It's only happened twice in my lifetime and 3 times in the history of this country. So we were trying to find a vehicle to be able to speak on behalf of the states and our citizens. And our document is I called it a friend of the Senate brief because I don't know what else to call it. It's a legal opinion to try to educate senators on why they should enthusiastically reject these articles of impeachment. Because I'm telling to all my Democratic friends out there who are cheering for this, I promise you, one day the shoe will be on the other foot. And this is what I don't want. But you're going to have someone in the White House that you support, and they're going to be accused of a political thought crime, or they're going to be accused of withholding information from Congress by lawfully invoking executive privilege, and you're going to be on the other side arguing the exact opposite. And I think that this is so important that this precedent today be set, that the Senate repudiate the House's articles of impeachment by rejecting them loudly. Thank you.
Question? All right, thanks all.
Yeah, thank you. Great job. General, great job.
General, hey, Dad's in Poland, Mom. Oh, so I want to get a picture of y'all. So he's a big fan of this. Thank you.
Oh my goodness. I'm Attorney General of Chapter. You would get that background. JEFF.
Okay.